last afternoon.
What order?
The order.
Right, it's a matter wherein the defense evidence has been closed. We give him one opportunity. What is there?
Let's see. हमारा last order. Last order.
Sorry, it's me. It's not fair. We'll pass it over. Yes. Do you have any objection? One opportunity being given.
It's not the first opportunity, my lord. This is
Doesn't matter. It's 31 opportunity. It's just an opportunity to lead defense evidence. Why should we close that?
If he's so bona fide, he should have filed section 91 that he's filed just after the report was passed.
There is a clear sign.
Yes.
Yes, please.
No, so the investigation.
ये बात है इससे हिंदी
We presume that you will be proceeding in the matter.
Lordship, please.
Now you tell us one. Today we may not finally hear you. Please release in the favor of the employees. This is what we had expressed the last time also.
Yes.
So 50% you release.
But may I?
We check up, there is no stay of the impugned order.
Your Lordship,
Only contempt.
So,
we will only stay what we propose to do.
Yes.
Rather, you should volunteer. Generate goodwill for your employees. Pay 50%, subject to the outcome of the petition. And how to protect, assuming that you succeed, is something which you will have to tell us or we can ask.
They are in-service employees. At all, you win, and the consequential directions can be given.
Yes.
No equities will be
All stages you have got.
I take
it the question was put to me, not to my learner. I have prepared a short note which I may hand over, which I would like to place for your Lordship's consideration before your Lordship passes any order with regard to 50%. Because I have two contentions.
Yes, Mr. Singhvi.
Whether I heard your Lordships, whether I just heard your Lordships, can I make one suggestion? The amount,
Yes.
when you draw a very big line and then one says 50%, it sounds reasonable. But your Lordship will appreciate that the amount for the state is gigantic, it's humongous. It is some 40,000. I'll give your Lordship the exact figure, I'll just take a minute to give that. It's a very large amount. 50% of that will be backbreaking. Your Lordship's three judgments hold the field. One, PA is not a vested right. Two, it is not a fundamental right. It will break the back. It will break the back of the state.
One minute, Mr. Singhvi. We have gone through your note. We have also gone through the judgments. There is someone else who joined. Unko mute करेंगे. Mr. Singhvi.
Yes,
we have gone through your submission. We have also gone through the application.
Because the
Single joined somewhere else. Mr. Singhvi joined somewhere else.
Yes, he joined in two courts simultaneously.
Doesn't matter, Mr. Singhvi, don't worry.
Only present.
So he can't hear that.
Unmute करिएगा. Mr. Singhvi को unmute करिए.
Well, I was putting my ear to the screen. That's all. I was not going
No,
anywhere.
that's all right. But what we see, we have gone through the judgments passed by the CAT, the judgment of the first round of the judgment, the second round of the judgment of the High Court, the order of the CAT, and the order
Well,
of... One minute, Mr. Singhvi, and the opinions of two honorable judges of the High Court. Now, what we propose to do is that two things that we can... We'll request you to come out with a figure 50% subject to the outcome, or we pass an order.
Well, I understand. Your Lordship may note 41,000 is the amount. I cannot give any answer to your Lordship on that kind of amount for 50, besides 10%, brothers. Your Lordship appreciate that. For a state, I can't speak like that. Number one. Number two.
These are your employees.
No, Maharaj, I can try and work out some solution, but I cannot promise anything to my lawyer.
What would be the consequence?
Number two, Maharaj, in the event, then your Lordship, Maharaj, may give us an afternoon the miscellaneous week. We'd rather argue it because it's a very huge financial backbreaking liability. In the miscellaneous week, we'll do some Thursday or something.
We have gone through your notes. We have gone through the judgment.
Well, it will require some
We are not inclined to even interfere. Let us be very clear.
I appreciate what my Lord is saying, but this is not a matter of that kind.
It is not a constitutional right. It is not a fundamental right. But nonetheless, because of your ROPA,
the reason, kindly appreciate, the single reason why this amount has become.
Exactly.
Mr. Singhvi,
Before ending.
Mr. Singhvi,
Yes,
we are very clear. Okay, we are passing an order. We will come to 50%.
Well, your Lordship may allow us to revert on Monday at least. Well, we haven't been. No, we have not been heard. Well, then your Lordship may consider this a very large amount. 50% is impossible. 20,000 crores.
We are scaling it down to 1/4 of Singhvi now. 40%.
Put it on Monday, Malas. Then let us take some instructions.
Not be possible.
Can it possibly be increased?
And thank you very much. What are you saying?
Only one subject matter is
No suggestion. Please go. Contempt will work out. Mr. Just a minute.
all it. But there's this one aspect.
We have heard him. Having heard.
Yes, that amount to be secure.
But there's one aspect.
These are employees in service.
Yes,
They put out we
Your
can
Lordship.
always
Board are cancelled.
Your Lordship.
And in this court, are you okay for the first time? Speak when you're spoken to, please. We request.
Just one aspect that I wish to raise.
You're doing the same mistake which she's.
I want clarify one fact.
Mr.
Retired employees.
Please, Sanjay Arjana. That's it.
Kindly pass the order which is closed their option.
Yes, Mr.
But my respectful submission is only this. That we have no difficulty in paying as per ROP. There's no difficulty there. There are two rubs in the impugn. The first is revise them twice a year. So we are submitting, so that is drawn from central government employees, which is not applicable to us. That's point number one. The point number two is revise it in the manner suggested by the tribunal. And there are certain findings which are returned by the tribunal, which say you will do it in this manner, which is virtually acting to central government. Right? So those are the two laws. The third law, that under Rule 12, areas are not paid. So we are submitting that no areas should be marked on, because the areas that they are calculating is on the basis that you not equalize as per central government and you not revise twice.
What will you do, Mr.
Yes. So may I suggest that now this one thing, just on equity. What we are paying them today, as per our interpretation, is 125% more from the time that the ROPA was applied in 2008. So yesterday, my lord, the submission was made before your lordship that we are not paying DA at all. That's not factually correct. we are paying to the extent of 125% over and above the scale in 2000.
What we propose to get.
Yeah.
Yet there's another thing also,
Yeah.
whether they would be entitled to the same amount as is being paid to those who are posted outside the state. That's the third thing.
So the third aspect is now rendered again because that part, Mullah, has been struck down by the tribunal. And that part, Mullah, we have discounted. So that third aspect of being at par is something separate. So may I suggest
You 1/4 of the amount which is due, you disperse without any equity rate. And we fix the matter, in July. We post it in July for hearing.
Right.
I mean, then counsel to the parties.
But Mullah, there's only one difficulty.
Yes.
I don't want to tomorrow be accused of not complying with your lordship's order because the impugned order says we'll have to work out the modalities. That's what the impugned order says, saying evolve norms for the purposes of payment in this manner. What your lordship may do is, it shouldn't go as my statement because
We'll not put it
if I make a statement, but what I suggest that your lordship say 25%, but give us a little bit of time to evolve those norms because that will require a lot of working out in terms of nitty-gritty of it says twice a year. But it shouldn't be twice a year because twice a year is
Right now, we are not increasing it to that aspect. It's a lump sum amount which is coming out as per the order of the High Court, strictly in terms of
there's no amount which has come.
When we-
Sorry,
which will follow.
in compliance. We have heard Mr. Singh, sir.
Well, one sentence, your lordship dictates for us one sentence.
Yes.
The highest slab of Mr. Patwalia's client's demand is based on twice a year. That's the main issue.
Correct.
Now, Malas, if Mr. Huzefa has got some instructions, then Malas 25% may be workable, but Malas,
No,
your lordship is hearing it. It may, Malas, it may be a back-breaking thing for the state. Financially, Malas, a DA will break the back of the state. We are not running away anywhere. My lordship's final decree will be obeyed. So give a Malas a reasonable percentage. Kindly give a reasonable percentage.
Can I make one suggestion? Let us take instructions over the weekend, just have it on.
Let me on Monday.
No, we'll come up with figures, sorry, so that there is no.
We made it clear, Mr. Singh, to you last week, and therefore we kept it. Having heard the concept of it.
Kindly be reasonable on the percentage, Malas.
So 25%, we agree with you, we are saying.
But it's irrecoverable also, as your lordship knows. It's irrecoverable.
Obviously.
Otherwise,
You have to consider
ready to go on with the final year in place state, set out for final year.
would release at least 20% of the amount due and payable to the employees in terms of the impugned judgment or dated students, so past students, so in case number students. So needless to add, dispersal of such amount shall be without prejudice to the respective rights and contentions of the parties and subject to the outcome of the petition. List the petitioner. The respondents are permitted to place on record their submissions within a period of 4 weeks, or let's say parties. Because they've gone through the same way. Perhaps you will have to file revise. Perhaps parties are permitted to place on record their revised submissions. List the matter for hearing on that.
Within some 4 weeks, 8 weeks, 6 weeks.
No, but the norms will have to be worked out. Your own answer is that.
Fix the time in terms of the High Court judgment.
We have said in terms of the High Court judgment. Implement we are not doing. No, implement we are not doing.
It doesn't matter at all.
Implement we are not doing.
They will be heard, perhaps because the people has already not been heard.
It may be heard because that's the final.
Implement simply tag along.
That's right. In fact, on the earlier question, I understood my lord said we already heard in the final.
Okay.
Icon 62.
But gentlemen, one thing is there, we are telling you on this side. See, if Mr.